The Beneficiary's Guide to Contesting a Will. When you contest a will, you challenge the legitimacy of the will in probate court. If a will contest is successful, the court will throw out the invalid will, and the deceased's property will be distributed either per the terms of an older will or under local state probate law. Importantly, you're unlikely to successfully dispute a will simply because you don't like what it says or you disagree with the property distribution. To succeed, you're going to need to be able to prove that the will is not legally valid. Can a will be contested? Yes, a will can be contested by certain parties under specific circumstances. Some of the most common reasons for contesting a will include 1. The legal requirements were not followed. For a will to be valid, the testator must follow specific rules and formalities as defined by state probate law. While the specific requirements differ among the different states, every will must meet the following conditions for it to be enforceable. The testator must be of legal age. They must be 18 or whatever the legal age is in that state. The testator must intend for the document to be a will. The testator must sign the will, and at least 2 witnesses must sign the will. Some states require more. Or the testator must have written the material terms of the will in his or her own hand. If the will doesn't satisfy these requirements, its validity can be successfully challenged. 2. Incapacity. In order for a will to be enforceable, the person making the will, also known as the testator, must have what's called testamentary capacity at the time it's created. To have testamentary capacity, the testator must understand 3 basic notions: that the document they're creating is a will, the amount and type of property they own, and who's going to receive that property under the will. If the testator doesn't have the mental capacity to understand these concepts, due to Alzheimer's, dementia, a stroke, or another disabling ailment, the will can be contested and thrown out based on the testator's incapacity. 3. Undue influence or coercion. Another common basis for a will contest is undue influence or coercion. Undue influence means that the testator did not make the will of their own free will, and that they were pressured into creating it or leaving property to someone when they wouldn't have otherwise done that. If the testator changed their will as a result of coercion or force from another person, then the will can be contested and deemed invalid. How to contest a will. To contest a will, an interested party, an heir or beneficiary under a prior will, will need to file a petition in the probate court in the county where the testator lived and died. The petition must be a formal, written document that outlines the reasons why you think the will isn't valid. You will want to retain an experienced probate litigation attorney familiar with litigating in that county's probate court. How long do you have to contest a will? All wills must go through a process called probate, which is basically just the process of administering the will and the person's estate through the appropriate county probate court. Once a will has been filed or lodged with the probate court, the countdown to the deadline for will contests begin. In California, you have 120 days to contest the will from the day that probate is opened. However, if you receive notice that someone has filed a petition that claims the testator died without a will, you should file a probate petition with a copy of the will with the probate court as soon as possible, and you always need to lodge the original with the court. How much will it cost to contest a will? The cost of contesting a will varies, depending on the particular facts of your case, but most challenges cost thousands of dollars, with minimum attorney fee retainers ranging from $5,000 to $10,000 to more. Successfully contesting a will is challenging, so you'll want to consult with an experienced probate attorney before you take any action. Whether a contest will be worth those costs depends on a variety of factors, such as the size of the estate, the amount you specifically might recover, and the strengths of your arguments and the weaknesses. A seasoned lawyer can help you evaluate your case and help you decide what is the best course of action for you. Who can contest a will? Only people who are considered interested persons can contest a will. An interested party is defined by state law. Generally, probate law will limit interested parties to heirs at law, whether named or unnamed in the will, beneficiaries of previous wills who were excluded in the current will, or others who might have a financial interest in the estate. Can a child contest a will if they're excluded or disinherited? Yes, if the decedent's child is excluded from a will or disinherited in it, the child can contest. These challenges are particularly effective when based on undue influence, fraud, or incapacity. A child may also be able to contest a disinheriting will if they can prove that their parent disinherited them based on a mistake of fact, such as an incorrect belief that the child was a drug addict, for example, when they were not. Children who successfully contest a disinheritance can often receive substantial reward. Can nieces and nephews contest a will? Nieces and nephews may be able to contest a will if they're determined to be parties at interest, which means that they have a financial interest in the estate. This would generally occur in situations where a niece or nephew is named as a beneficiary of a former version of a will or is named as a beneficiary of the current will. Have questions? At RMO, we help people like you every day. Give us a call, shoot us an email. The consultation's always free. Thanks for watching.